a lecturer at the University of Notre Dame, Australia, and has lectured at a variety of universities, including the University of New South Wales and the University of Western Sydney. He has completed a Bachelor of Laws degree, Bachelor of Science degree, and a graduate diploma in legal practice at the Australian National University, and a Doctor of Philosophy degree at Curtin University. Thank you very much.
Great, thank you. So what I wanted to talk to you about is the issue of same-sex marriage and religious liberty. So in Australia at the moment, we have an issue that's ongoing regarding what kind of protection should be provided to those who have a conscientious objection to same-sex marriage. So last year, I'm not too sure how many of you follow Australian politics, but last year we had same-sex marriage introduced into Australia. It was preceded appropriately by a popular vote. So unlike in the US, where you had the issue ultimately decided by the Supreme Court, in Australia, although there were some people who were reluctant to this to occur, we did have a postal vote, and that vote was in favour of same-sex marriage. It was fairly decisive, 62 to 38, so that's obviously a clear affirmation of the view of Australians that the laws should change to allow same-sex marriage, but there was still a significant number of people who were not keen for there to be same-sex marriage. So before the vote occurred, there were a number of bills that were introduced to indicate to the people what would happen if the vote was in favour of same-sex marriage. All of the various bills that were introduced, they were private bills. They had very limited protection for religious liberty. And the view was, including among many of people who voted in favour of the laws, was that if the vote was yes, there'd be changes to the bills that would be ultimately enacted. So the vote was in favour, but there was a huge rush to bring the law into effect before Christmas. So the vote came in favour in around mid-November, and the Prime Minister at the time was from the Conservative Party, but was keen for there to be same-sex marriage. So he was widely regarded as someone who was, if you like the term, progressive, but because of his political manoeuvring, he was able to become the head of a Conservative Party. It didn't last very long. As some of you might know, he was removed from power a few weeks ago. So it was an interesting outcome of our political scene. So Australia's become quite a politically unstable nation. At least we have had 7 changes of Prime Minister in the last 11 years. That's an indication that we do have a few political problems. But he was Prime Minister at the time that we had the same-sex marriage vote. So he was very keen to bring into force same-sex marriage. So you had the head of the Conservative Party in favour of the change. You also had a number of politicians in the Conservative Party in favour of change, and also the other parties as well, which you might call the more progressive parties, who are obviously in favour of the change as well. So there was more than enough political momentum to bring same-sex marriage, to enact the laws for same-sex marriage whenever they wanted, and the view was that it should happen as quickly as possible. So there were a few amendments introduced for the bill, but they were all rejected, which astonished many people in Australia, including those who voted yes, that there were no changes to the bill that was introduced before the vote, and so that was the bill that actually became enacted. And in the law that currently exists, there's very limited protection for those with a conscientious objection. There's protections for those who are religious ministers, who obviously won't be required to enact same-sex marriages. There's also protection for those who are civil celebrants, who can register themselves as religious civil celebrants, and so they also will have protection. And then there's also protections for organisations established for religious purposes. They are not required to have their accommodation used for a same-sex marriage or a celebration related to the same-sex marriage, and they're not required to provide goods and services. But they're the 3 key protections. So anyone who's been following this area will know that those protections are inadequate in order to provide comprehensive protection for same-sex marriage. So due to this lack of protections, there was widespread community concern, and the government, somewhat reluctantly, as I mentioned, because the Prime Minister was not all that supportive of the concerns of conservatives who have a conscientious objection to same-sex marriage, but nevertheless he did establish what became known as the Expert Panel on Religious Freedom to look at Australia's laws. And it turned out to be broader than just focused on same-sex marriage. So the role of the panel was to go throughout Australia to talk to people in Australia about what additional laws and policies needed to be enacted to show appropriate respect for religious liberty. So that panel gave its report to the government about 4 months ago, and interestingly, the government still has not released the report. Partly that is due to the controversies that we've been having at a political level, that we've had a change of government, and there may be also concerns regarding the complexities of regulating this area, because it's not just focused on same-sex marriage, it's on any issue regarding religious liberty. So inevitably it will be complex, and so due to these issues the report has not been released, and we still don't know when it will be released. There's an election that will occur sometime in the next 6 months. It could be in the next month or two, we don't know. So due to the political uncertainty in Australia, we have no idea when this report will be released and what steps the government might take to enact the recommendations in the report. But it will have to happen at some stage. Everyone's waiting for the report to be released, and when that report is released, there'll be a need to focus on how religious liberty is protected in Australia, and particularly in the context of same-sex marriage. So that's what I wanted to focus on today, this issue of same-sex marriage and religious liberty, the kind of protections that should be provided and the merits for providing particular protection. So firstly, on the issue of conscientious objection. So people can have a conscientious objection to being involved in same-sex marriage, I think broadly on 3 grounds. The first one is the religious one, which probably accounts for the majority of people who have a conscientious objection. So they are Christian or Jewish or Muslim or some particular religion, and they have an understanding that marriage is inherently a male-female institution, and even with the understanding you can separate the civil from the religious side, they still will consider that having marriage described at a civil level as being between 2 persons would undermine their understanding of marriage. So they reject this idea that you can separate the civil and the religious understanding of marriage. So that, I think, accounts for a substantial amount, if not most, of the objections to being involved in same-sex marriage. Another source of objection is what you could call a historical or an essential understanding of marriage. So some of you would have read the book Robert George, Sharif Gurgis, and also Ryan Anderson, What is Marriage? So they famously made this kind of point as well, that marriage is inherently a one-man, one-woman institution. And the reason, and that's not a religious position, it's a philosophical, historical, cultural position, because of the understanding that when men and women have sex, sometimes a child is going to be reduced, and that child needs to be cared for the child's own welfare, but also for the good of the community. And so you have the institution of marriage arising throughout the world in a range of different cultures to address this social need that children need to be cared for. And this was the argument that was made by people in the US Supreme Court. So the Chief Justice Roberts made this point as well, where he talked about marriage arose as a heterosexual institution, not to exclude gay men and women, but to meet some need of the community. And that's why you have marriage understood as a one-man, one-woman institution. And he talked about it being, the Han Chinese recognised this. All these different groups in the world that had no contact with each other still recognised and established this institution of marriage as the one-man, one-woman institution. So that's a second basis on which people will have a conscientious objection. They don't want to be engaged in promoting a concept of marriage which contradicts this understanding of marriage being a one-man, one-woman institution. That's important for a reason which I'll come back to later on in the presentation. A third basis for people having a conscientious objection to same-sex marriage is a consequential one, that they recognise that if marriage is to be redefined, it will have a range of adverse consequences. So one, which I'll talk about in some detail, is that it has adverse consequences for those who have an objection to being involved in marriage. Many people won't compromise their commitments and they are willing to suffer as a consequence. They'll lose their job, they'll lose their business. In rare cases, Kim Davis' case in the US, they'll go to prison. So that's another key reason why people have this objection. Also, they're concerned about how the redefinition might play out in terms of other social debates that we're having. So one issue is in regard to the transgender movement. People consider, although they recognise that they're separate, they consider if marriage is redefined as a two-person institution, it might add momentum to other social movements with which they disagree, and the transgender movement is one. So that was one of the most effective strategies that the organisations in Australia used to build support against the redefinition of marriage. They were saying that if you redefine marriage, it's going to add support to the transgender movement. So in Australia, we have a program called the Safe Schools program, which involves the transgender movement. So people will go into the schools and they'll try to promote this view that you're a man or a woman depending upon your feelings, upon your thoughts. It's not a biological one. And so many people changed their view from being in favour of redefining marriage to being against redefining marriage on this basis, that they were concerned about what kind of consequences it might have. So what that shows is those who have a conscious objection to same-sex marriage, it's not only going to be on the basis of religion that they have this objection. It will be on these other grounds as well. But it is fair to say that most of the conscientious, that people who have a conscientious objection base their objection on their religious understanding. And so it's worthwhile reflecting on how a just state would regulate this area to, if they are going to introduce same-sex marriage, how to do it in such a way that respects those who have a conscientious objection, which will often be based on religion. So naturally, if you take a human rights approach, that's going to involve a range of considerations, such as freedom of speech. There's a range of cases where freedom of speech has been relevant, so the Master Cake Bakery cases in the US, which has gone to the Supreme Court, Ash's Bakery, case where these artists, they decided to pursue a career as an artist through baking cakes, and if you look at their cakes, they are artistic works, and so they argue being forced to bake a cake is an expression of their freedom of expression if they have to do it to support something they disagree with, which in their case is same-sex marriage. So freedom of expression is raised, freedom of association is another one as well. So if you create an organisation which has an ideological commitment or a religious commitment and you force it to act in a way which is contrary to that religious commitment, say by being involved in a same-sex marriage, it can be understood as a violation of freedom of association. It raises issues also of rights of parents, the rights of children, which can go both ways. People argue that it's important for same-sex marriage for people not to have protections for conscientious protections, because it will mean that the children of same-sex parents will suffer in a range of ways. So if a person can be denied a service to their marriage, then they and their children might view this as emotional harm or somehow recognised as an assault on their dignity, if you like to use that kind of terminology. And we saw this case in Klein in Oregon. It's another US case where a lesbian couple were denied the bakery goods, bakery service, and they consider this to be an emotional harm. And so those people who, if they have children as well, they can also understand this as being a type of harm to their children. But also those who have a conscientious objection, their children can suffer as well if they're forced to close down their business, if they lose their employment. So the rights of children can go both ways. Also, there could be other considerations. So in Australia, there's quite a lot of emphasis placed on Australia being a multicultural society. And in the vote for same-sex marriage, it was carried in most electorates except for those electorates where there was a high immigrant population. So where we had a number of people who came from the Middle East, in those areas, they were conservative Christian and conservative Muslim. In those areas, they voted no. A majority of people in those electorates voted no. So some people argue if the state, Australia, wants to show appropriate respect for multiculturalism, then they should ensure that there is conscientious protection, because if you don't provide that protection, it will have an adverse impact on people due to their cultural background, their cultural commitments. So there are a range of considerations that are relevant that a state should take into account in determining how the issue should be resolved. But the two central ones, as you would know, are religious liberty and equality. So for religious liberty, I expect anyone who's come to this kind of conference would know that in the international human rights instruments, religious liberty is emphasised as being a right of fundamental importance, but it's also recognised to be not an absolute right and can be limited on a range of grounds. So the ICCPR, as you would know, it can be limited for public safety, order, health, or the rights and freedoms of others. And people argue that religious liberty is important, but it can be limited when it conflicts with other rights. And the right that's often referred to is the right to equality. So in working out how this conflict should be resolved, it's essential to work out how important the religious liberty claim is in this particular context. So you'll be familiar, I suspect, with a range of cases where judges talk about how cautious courts need to be about going into communities or trying to take the perspective of the community to try to work out how important a particular commitment is. The argument is that secular courts are ill-equipped to be able to accurately assess externally how important a religious commitment is to a religious adherent. So although that's a fair point, there's still a need for a court, for a government to engage in some degree of assessment of the importance of that particular religious commitment to the religious adherent to work out what kind of respect is required by the government in relation to that religious commitment. So an example that I always think of is for a Christian, some Christians understand they have a religious obligation to wear a cross. They also understand they have a religious obligation to attend church on a Sunday. Both of them would be recognised as an authentic expression of their religious beliefs, an obligation imposed on them. But most Christians in those circumstances would consider the obligation to attend church to be a more important one than the obligation to wear a cross. So a law that prohibits them from attending church will likely be considered to be a far graver violation of their religious liberty compared to one involving the obligation to wear a cross. So considering that difference and the need to recognise the importance of religious commitment, it's necessary to reflect on the importance of marriage to people who have a religiously informed conscientious objection. And for many people of a religious bent or religious commitment, marriage is of fundamental importance. So from a Catholic perspective, as many of you will know, it's one of the 7 sacraments. For many other Christian denominations, there's a similar emphasis on marriage being of fundamental importance. And Christians who take this particular approach are very much against acting in any way which involves compromising their religious commitments to marriage. And we see this in a range of cases which you'll be familiar with. I've mentioned some of them already, but there's now many cases throughout the Western world, and I expect perhaps in South America now as well, but you'll have to tell me more about those examples as well. But businesses have been closed down after their refusal to facilitate same-sex marriages. Individuals have been fired or disciplined when their objection to same-sex marriage has become known, or their refusal to participate in same-sex marriage has become known. Governments have denied benefits to individuals who want to use government services. We've had vilification laws be used against people who have same-sex marriage. So in Australia, we had a Catholic archbishop in one of our jurisdictions who wrote a short document called Don't Mess with Marriage. The document was sent only to Catholic parents. A transgender activist found out about the document, it was probably available online, and made a complaint to the Human Rights Tribunal in that jurisdiction saying that it was a violation of vilification laws on the grounds of homosexuality. And the court, the tribunal, could have ruled it inadmissible to begin with, but said there was sufficient basis for it to proceed to the next level, and so it went to conciliation. The Archbishop had to hire expensive lawyers. There was an ongoing dispute. It was it was a matter of national discussion, and the view was that people realised that this was undermining the movement to try to redefine marriage in Australia, and so the transgender activists withdrew the case. If they wanted to, they could continue it, but they haven't yet. But it still made the point that anyone who wanted to discuss same-sex marriage in a critical way ran the risk of being taken before a tribunal. So that's another example of how individuals can be harmed if they don't support same-sex marriage. And so all of these indicate that for many people with a religious commitment, same-sex marriage and the refusal to support it is something that's incredibly important to their particular religious commitments. And so what this does, I think, prove is that in terms of the government working out what is a just approach to regulating same-sex marriage, it's clear that same-sex marriage and the refusal to implement it is something that's critical for those with a religious commitment. And so once you accept that there is this strong basis for religion for those who have an objection, it's necessary to reflect upon whether there are any sufficient grounds to actually limit it. And so inevitably the argument is made that equality is something that is a sufficiently strong basis to justify religious liberty being protected on this basis. And so what I wanted to do was just to discuss this issue in terms of how religion and equality will conflict in this case. So one approach that people could take is simply that equality is more important than religious liberty in this case, and it needs to triumph. So there are many people who talk about it from their own experience or rely upon cases to justify this. So Christoph made this point yesterday when he talked about the South African case of Stridham, where it's a well-known case involving as Christoph said, it was a man working at a Christian academy as a music teacher. Once it became known that he was in a same-sex relationship, he was fired, and it was devastating for him. He was no longer working, obviously, and without his income, he had to sell his possessions, including his piano, and he went on to suffer a psychiatric illness. So it had a major impact on him. It wasn't quite in the context of same-sex marriage, but it does indicate those who suffer from discrimination can experience significant adverse harm. In the case of Klein, involving the bakers who refused to bake a cake for those in a same-sex marriage or same-sex civil ceremony, the two lesbians, talked about how it was profoundly emotionally disturbing to be denied the cake for their celebration, and the judge or the tribunal member or the Labour and Industries Commission, whatever it was, agreed that what they experienced was profoundly unsettling for them, a very severe harm to their emotional well-being, and gave an award of $165,000 US, which was a substantial payout causing the business to be shut down. But it's a further indication that there are many people who understand themselves to be profoundly harmed by a refusal of service, including in the context of marriage. And so many people reach the conclusion that when there is this clash between equality and religious liberty in the context of provision of services for same-sex marriage, the equality claim must triumph. So in response to that, I think firstly it's important to reflect upon, well, one response to that is to just disagree and say, no, religious liberty is sufficiently important in this case that religious liberty should prevail. And sometimes you see that argument, that it's that simple. Someone will just say equality is more important, other people will say religious liberty is more important, and so you have this clash. That's one way in which it works, but I don't know if that's very effective, and it doesn't really seem to work that well for those people who are very strong on the equality claim. Another way to approach it is to reflect on international jurisprudence in relation to equality. So some of you will be familiar with the case of Jocelyn, the Human Rights Committee established under the International Covenant on Civil and Political Rights. So this involved a New Zealand lesbian couple who argued that the New Zealand government's refusal at the time to introduce same-sex marriage was a violation of the ICCPR. It went to the Human Rights Committee, and the Human Rights Committee held that the right to equality under the ICCPR does not require a state to introduce same-sex marriage. So you could argue that, fine, that's the position under the ICCPR, but once a state introduces same-sex marriage, then it is under obligation under ICCPR, other human rights instruments, not to allow those people to deny services to that same-sex marriage. Once a state introduces same-sex marriage, everyone has to provide those goods. However, it seems that it's also possible to argue that if it's not a violation of the right to equality for a state not to implement same-sex marriage, then it's at least harder to say that it's a violation of the right to equality for someone not to provide services to that same-sex marriage. It seems like there's something that can be argued there to make it harder for a person to rely upon equality to say that the right to equality is violated by someone who does not provide their goods to a same-sex marriage. So that's another, I think, important response to the equality argument. But I think the stronger one, and perhaps the one which is, I think, most effective, is to actually recognise that the right to equality is a right that can be relied upon by those who have a conscientious objection to same-sex marriage. So as I mentioned, often the basis of the conscientious objection will be religion, which is clearly protected as one of the grounds of the right to equality in the ICCPR and many other human rights instruments. There are other grounds that can be relied upon as well, so political opinion is an example of one, culture if you want to include that. And so what you can do, which I think is more effective, is to set it up as a clash between equality claims. You have the same-sex couple who rely upon equality, and admittedly, to be critical of their position, homosexuality, sexuality, transgender status is not a ground protected explicitly in any of the instruments, but it's included because the instruments typically have or other status, and so it's implied in there. But religion is something that is explicitly included, but I don't think there's much that can be made there. But you set it up as a conflict. So it's the right to equality that the same-sex marriage people can rely upon versus the right to equality that those with a conscientious objection can rely upon. And so once you recognise that both sides can rely upon the right to equality, I think what needs to happen then is there needs to be a deeper focus beyond just a rhetorical appeal to rights. You need to actually focus upon what the impact of different approaches are to individuals who are denied the goods or alternatively forced to provide the goods against their conscience. So for those who want goods from a particular bakery or a florist, or they want to have their marriage celebrated at a particular location, it should be recognised that they sometimes can be harmed significantly, as I've discussed. But it also should be recognised that in the majority of cases, these people, if they've done a search on the internet and they call someone up and they say, I want some flowers and some cakes, and the person says, sorry, we don't provide goods for those in a same-sex relationship. That's going to harm some people. They'll find it slightly offensive, but there's obviously, all they have to do is just hang up and call the next person in the list. So the burden for most people with the same sex who wants to have services for their same-sex marriage is not going to be that significant. And if they consider that they're going to be, if they're very vulnerable to emotional harm in these circumstances, then they can just ask friends who've had same-sex marriages to recommend someone as a florist, as a photographer, where they could get married, where they could hold their reception. So there's ways that they could easily take to avoid even the possibility of encountering someone with a conscientious objection. But those with a conscientious objection, the kind of harm that they suffer will sometimes be much more profound. So as I talked about, there'll be circumstances, and there have been circumstances, where businesses have shut down, where individuals have been fired, where people have been taken to courts for engaging in what they call hate speech. In very rare cases, there can be people who'll go to prison rather than compromise their commitment. And these people, there are no alternatives for them. If they're running a business and they're being asked to provide their flowers or their services to the same-sex marriage, there's no alternative. They either have to compromise their conscience or alternatively, they can stay true to their beliefs and suffer the sometimes grave consequences. So it seems, when you look at it from a comparative harm analysis, the harm suffered by the same-sex couple and their loved ones is much less than the harm that's suffered by those who have a conscientious objection. So it seems on that basis that the equality argument provides more support to those with a conscientious objection. And it seems to me to be a strong argument, and it's unfortunate in Australia that it wasn't used more, because I think it could have been far more effective. There was some attempts to use it in some of the ads they used, where the claim was made that children have a right to equality, which would make sense, that the children benefit from being raised by their mum and their dad in a committed marriage. So that's a good argument, and the view would be that if you introduce same-sex marriage, you might weaken the institution of marriage, so people would hate that kind of argument being made. But there are people who say that changing marriage from something that's based upon being a man and a woman and the biological reality that children can be created from that, and changing it from that historical, cultural institution and changing it into a two-person emotional sexual union undermines marriage. And more importantly, it's an argument that's made by Robert George and that this kind of emotional sexual institution of marriage can't even explain core concepts of marriage. It can't explain why we should regard marriage as a permanent institution. If it's purely emotional sexual, surely marriage should fall apart, it should no longer continue when there's no longer an emotional or sexual attraction between the couples. Also, why should marriage be only between two individuals? If there's three people, I don't know, in Brazil and other South American countries who've had three-person institutions, civil partnerships recognised. So why not have more than two people when if it's only an emotional sexual union? So all of these kind of arguments can be used, and I think effectively so, but at least in Australia, there wasn't much use made of the right to equality, that those with a conscientious objection have a right to equality to ensure that their rights are effectively respected. So it'll be interesting to see in the months to come, the next 6-12 months, whether this argument will be used more. In the things that I've written, I've tried to emphasise the importance of using these kind of arguments to argue in favour of there being strong protection for those with conscientious objections, but it will be interesting to see how it goes. So I know I'm approaching 30 minutes. In fact, I've already gone over 30 minutes, so I might stop there, but I'm very interested to hear your views on the topic. Are there arguments you think that are useful to make in this kind of point, and anything else you might want to ask or contribute? Thank you.
Thank you very much, Professor. I would invite you to sit here, please. And then I'd like to hear from you if you have any contribution or questions for Professor Dr. Greg Walsh.
Yeah, well, I think I accept what you were saying, that there's a good point that can be made, that there's different ways of reflecting on this issue, that both people can still talk about the emotional harm that they suffered, both people can rely upon the right to equality, both people can rely, also I didn't mention it in the point, but people also talk about both people being able to rely upon the right to religious liberty in this case as well. So they talked about religious liberty obviously being something that was supported by those who were against the marriage redefinition, but also religious liberty was something that could be used by those people who wanted marriage to be redefined. That it was something, if those people, especially in some of the Christian denominations, they were saying that same-sex marriage was something that they should be allowed to do, and the laws were preventing them from being able to celebrate same-sex marriage within their own religious community. So it's interesting that all of the arguments that are raised by one particular side can often be also used by the other side as well, and so it just indicates that it's a complex issue, and that some people, if they think this one particular argument's going to resolve the issue or be a definitive argument in favour of a particular way, it's just not the case, that it can often be used by the opposite side to make that case. And that's why I thought equality is so good, because there's so many people who consider the equality argument to be profoundly important to decide the issue, especially so in Australia and in America, the slogan was marriage equality, and so that was incredibly effective in changing people's views. But a powerful response could have been for those who were against redefinition to say that they were supportive of marriage equality, that they just had, it was different understandings of equality they both had, and if they'd done that, I think that would have been an effective way to have deprived those who wanted to redefine marriage of such a powerful argument. So, yeah.
Please.
So, at the beginning, you identified 3 kinds of grounds for a conscientious objection, and some are clearly religious, but then you had some that are more natural law, like Robert George, and others are consequential. I mean, I guess my question is, how broad is the concept of conscience? And you end up having worries about it not being broad enough, or it's too broad and therefore justify too many things and it makes things unworkable in society. I mean, the problems where you've got all the doctors in the country exercising conscientious objection so people can get services and so on. So the question about the breadth of conscience.
Yeah, I can see there's definitely a problem that if you start claiming every single concern that a person has about doing something which the law requires, and they just rely upon a conscientious argument of conscience and saying, that's against my conscience, I shouldn't be required to comply with that. I think that's a good point. Yes, in terms of how you actually go about defining what the ambit of conscience should be, I'm not too sure how you'd go about doing that. I can definitely think those 3 bases are legitimate in terms of why someone could say they have a conscientious objection to doing it. So people have a conscientious objection to engaging in war because they consider the consequences of doing so are so adverse. It's not always going to be religious. It's not even also always going to be solely based on principles, the idea that it's never justified to kill someone. Sometimes it will just be this particular case. I don't think this war is unjust, and so on the basis of the consequences which I consider will come from this war, that I don't want to be involved in it. So it seems like those 3 that I discussed are legitimate to say that they have a basis for a conscientious objection. In terms of whether you can provide some kind of general principle to work out when something should not be regarded as a conscientious objection, when some should, I think that's probably not possible. But
Okay, and I'd like also to contribute. I read an article by Josh Drackock about, and he says this, and I quote, "Market forces are capable of solving most cases of material hardship when religious objectors decline to provide services. Though many business owners and organizational directors hold religious objections to participation in same-sex marriages or providing controversial reproductive services, a greater number hold the opposite view." That is, he defends that the accommodation of these conscientious objections, because the market itself will solve these issues. Well, if you go to a baker and he objects to your to your request, you go and you go to the other street, there will be one that will do it. And I'd like to know whether you agree with this, the market force able to solve this, and the issue of some scholars who defend the idea of the undue hardship, that is, unless there is no other baker, no other photographer, then this right to conscientious objection will be limited in order to provide the service. This way you will have the two rights being fulfilled. Well, the service will be provided and the conscience will be accommodated.
Yeah, I agree with that. I kind of made that point that in the majority of cases, it's going to be very easy for those who are in a same-sex relationship to obtain their services. It's only going to be in a very, very unusual circumstance where someone wants to get married in some remote country location. There might be one baker or one florist there. That's a very rare situation where that would happen. In the vast majority of cases, it'll be so easy for someone to get their services from someone who doesn't have a conscientious objection. And also on that, the number of people who have a conscientious objection is fairly small. So those who refuse to provide their goods are not a significant percentage of the population. There's the profit motive that will overcome a lot of people who have a conscientious objection to it. There's also a fear of the adverse reaction from it. That's why, in a sense, there may not be a legal need to require people to provide their goods and services, just because the nature of social media and the aggression of so many people who are against individuals not providing their services to those in a same-sex marriage, that once it becomes known that a particular baker or a florist won't provide their goods to a same-sex couple, there'll be many people who will boycott those individuals, and even if they're not legally forced out of business, they may be forced out just through the boycotts. And this happened in the Klein case, where not only was there a boycott movement against the bakers, there was also protests outside the bakers. So it indicates how some people who are in favour of this redefinition, they're incredibly aggressive. And so, in a sense, they don't actually need to have the laws to require the provision of services, because those who are willing to not provide the services are going to suffer significantly from their decision not to. And so if it's their decision not to provide those goods, even if they know what the consequences are, I don't think the law should be requiring them to do so. And the other point I suppose I'd make is also just the generational change, that most of a high percentage of people who are, say, 50 plus were against marriage being redefined. But then those who are 25 and under, it was overwhelmingly in favour of marriage being redefined. So as the years go by, the number of people who do have a conscientious objection to providing their goods to same-sex marriages are likely to further decline. And so it'll be even rarer to see individuals not being provided with their goods. So that is a good argument that the market's going to take care of this issue, and you don't need a law that forces people to provide their goods, considering how few people are actually not wanting to provide their goods to a same-sex marriage. Yep. Yeah, Barry,
Okay.
I was running out of time. Oh, that's whatever.
A very short question, please.
Well, I'm just going to play the devil's advocate on this concept of the market forces, because, I mean, the whole human rights regime, people could have had the same idea. Like, for example, in Toronto, many people discriminated against Jewish people, didn't serve them, et cetera, et cetera. I mean, we can make that argument with all of the human rights protections that we have. Why should the market argument be good here, but not good dealing with race?
Yeah, that's true. But people did make that argument in terms of race as well, that the market would take care. If someone was not willing to employ someone because of their skin colour, it would mean that their business would not be as effective as someone who was only going to employ on the basis of merit. And so that business would outcompete the business that was going to engage in unjust discrimination. So that argument is made in other circumstances. But also, the circumstances have changed, technology has changed, that social media is just such a huge difference in our society. And so if someone does engage in conduct that is widely considered to be unjust, it's so easy for people to know about it and for them to suffer the consequences for it. So the need for law to be active in these areas is reduced compared to where it used to be. People say it's still important to have law as a symbolic role, to make a symbolic statement about the equality or the irrelevance of these kind of characteristics, which I think is true, but it still shouldn't take away from the fact that if the law isn't needed, then you shouldn't implement it, especially when it's going to have adverse consequences for some people who, in my view, should be protected or shouldn't be forced to act in a way that's contrary to their beliefs.
Okay, thank you very much, Professor. We really appreciate your contribution. Thank you very much. Então, dando continuidade à nossa programação, nós teremos, nesse momento, um painel e eu gostaria de chamar para compor a mesa desse painel o professor Dr. Cole Durham, Jr., professor Dr. Barry Busey e o professor Dr. Juan Martin Vives. O professor Dr. Uziel Santana, infelizmente, não poderá participar, está em outra reunião aqui na própria Mackenzie. And there will be a short panel discussion as we are out of time. And in Brazil, time goes quickly than any other country. But the idea of this panel, and this idea came from Dr. Uziel, that we're discussing here cases of low-intensity discrimination, as Juan Vives said, or non-lethal discrimination or persecution, or as Dr. Uziel used to say, symbolic violence or symbolic discrimination. And we chose each of you for specific reasons. Dr. Juan Vives, because of your work and your speech on religious minorities and the low-intensity discrimination in Argentina. Professor Barry Busey, for your work and speech on this non-lethal discrimination applied to universities and confessional organizations. And Professor Cole Durham, for this non-lethal persecution or discrimination against also religious individuals when it comes to the LGBT group and gay rights and all these topics that we have been discussing. And the idea of this topic is for each of you share some insights on the way forward, or how can we respond to that, to this symbolic violence or non-lethal or low-intensity discrimination in order to accommodate religious belief in the light of the anti-discrimination law and the claims for equality. And I'd like to hear from you, 5 minutes for each, regarding the way forward, how can we respond to this symbolic discrimination or low-intensity discrimination. And it's up to you. Who wants to start? Who wants to be the last one?
In the order of the program.
So you mean in the order of the program? So that will be Uziel. He's not here, but that will be Cole. Professor Cole, please.
Okay. I'm just going to give some spontaneous ideas. One thing that comes to mind is one of the best pieces of advice I received as a young man was someone who said to me, "You need to learn to be strict with yourself and liberal with others." And I think that sort of practical advice is something that we need in this area. I'm really intrigued by the notion of low-intensity discrimination, but you know, it's clear that at certain levels, there's a threshold that really ought to be non-cognizable. That is, there's a lot of little things that go on in life. Is this? I'll bite the microphone if I can. Is that better? Yeah, that's better. Okay. Yeah, I've never been a rock star, so this is a this is a very tough adjustment for me to make. But I think one of the things that we need to understand is part of the cost of freedom is that we have to put up with a lot of free activity of other human beings, and so I think we need to have thicker skins ourselves, be a little bit more inclined to roll with the punches, so to speak. At the same time, I think we need to discipline ourselves to be more sensitive to other people's concerns. Psychologically, we work in the opposite direction. We're more sensitive to our own pains and less to the pains of others. But I think we need to work in the other direction. One of the things I found myself thinking about during Greg Walsh's presentation is in addition to market kinds of forces, I think it's going to be interesting to see over time how different kinds of ethical forces play out. So I have a very practical wife who's the one in our house that goes to the baker anyway, and she just says, look, if it were me, I object to same-sex marriage. That's a religious principle. I believe I should love other people. That's a religious principle. And guess which one's more important? And so it's interesting in this area, a lot of the problems are complicity problems. I have to say, when I taught criminal law, I spent a lot of time on complicity, and I think it's very interesting. But it may well be the case that some other principles should override complicity. But that's easy for me to say, because in my ethical and religious system, I think I would sort these things out differently. But there are some things that I believe in and I would conscientiously stand for, and I am deeply sympathetic for and empathize with those who have those kinds of situations. I think one of the things that may help to some extent is, Mark Hill talked to us yesterday about religious literacy. We need to know what is important to people, but it may help to also know what is not important to people. I think that part of finding solutions in these areas will turn on sort of a richer sense of forgiveness, a richer sense of empathy for other people. I don't know how else we're going to go about finding sympathetic ways to go forward. But I think it's important to say this doesn't mean the idea that you should cultivate empathy doesn't mean that you have to abandon your own beliefs. I hesitate to speak for God, but I think God has a lot of empathy and love for us, and I think He doesn't change His mind on some of the principles. So, I think that's something that we need to think about. I have this sense that it will turn out that if people are working on issues of goodwill, there will be more possibilities for solutions than we imagine right now. And what we need to cultivate is some of that creative seeking of solutions rather than kind of a puritanical insistence on some principles that sometimes let us forget other principles that may be even more important.
Thank you, Professor. And now, Professor Barry Busey, please.
One of the things that I have been picking up quite extensively as a result of the Trinity Western case, but also the marriage case that was involved in Canada and other cases that we've been working on, is that there is, I think within the legal community itself, there's a lack of understanding of religion and the convictions of religious people. I think there's a sense of a very a right and wrong positions. I think it's like religion by definition is wrong, that when a Christian university wants to have or get involved in the public sphere, that somehow it's going to be an educational system that's not going to be up to the secular standard. And there's almost like an inability to even conceive that religious communities are rational. And I find that very interesting, because if any of us have ever read any kind of history, we'll know that universities have been around since only about the 6th century, and they were religious. And it's fascinating. In Canada right now, we have an organization called Universities Canada, and only universities that are members of this organization are receiving various government benefits and so forth, but also those universities that are in the club get to transfer their programs to other universities. So if you're a student in one university and you've graduated with a bachelor's degree or whatever, you can go to law school at another. You can, get accepted into med school because you're members. But the smaller Christian universities are not able to make that club. There are one or two that are, one being Trinity Western, but very, very few. And the rules are being changed to make it even more difficult for other religious universities to make it into Universities Canada. And what's happening with that, in my view, is this concept that it's a subpar education that's going on in the smaller schools. And yet, many of the students who would be attending these schools are able to pass, LSAT exams, MCAT exams, and so forth, but nevertheless are now making it into other programs. Now, there are some exceptions, but by and large, it's difficult. Anyhow, all of this to say that there is this, I think, a lack of understanding and lack of knowledge of the religious community within the legal profession and other professions that's becoming very problematic going forward. If you, I'm sure you probably would not want to take all the time that I've had to do with respect to reading the transcripts of those who spoke at the law societies and so on, but you get this real sense that religion just simply does not have it. How is it that we could have just a rational debate when you have a religious community is stuck on this ancient book and paying attention to that? So anyhow, how do we go forward? I think it becomes important for us within the religious community. The first reaction is anger. I think it's almost like we go through the stages of grief, and I very much appreciate the statements as Cole mentioned. We in the religious community have also got to understand the other side and understand how it is that they have that understanding of the religious community. And what can we do to be reaching out? What can we do to encourage a society where there is dissonance? We are going to have differences of opinion on what I call the fundamental life issues: marriage, abortion, and so on. And how can we live on the same piece of real estate? And the only way we can do this is to recognize that there are going to be points where we're going to have to agree to disagree. And so that's going to mean more involvement. I think some of the involvement that needs to happen is that Christians need to be, or people from the religious community, I'm speaking because I'm a Christian, but I'm saying all religious communities, will need to get involved in the various organizations. For example, it wasn't too long ago when the idea of a Christian being a lawyer was something absolutely forbidden. I mean, you know, my grandmother said I was such a nice boy when I was in the ministry, but then I went into practicing law. You know, it's like there's something about the practice of law that has this idea that, no, that's of the world. Well, I think we're reaping the whirlwind of us not being involved in the professions as we ought to be. So I think engagement, being willing to listen to the other side, being willing to understand where they're coming from, I think is extremely important, that there is this dissonance, and we are to, I think, work within that. I think at the end of the day, what it comes down to is that we simply are at points where we're not talking to each other. We're talking either above or underneath each other, and I think that ultimately has to change, and we have to be willing to engage. One of the things that our office has been doing is reaching out to various leaders in the LGBT community and so forth, who have an absolute position that they want, for example, to have all religious communities not have registered charitable status and so on. But we're actually involved in some dialogue with them, and it's very informal. It's very, you know, we're not grandstanding or anything like that, but we're just simply trying to understand. And I think that's something we have to do.
Thank you very much.
Right there.
And Professor Juan, please.
Thank you. I would like to take a moment to fix something I forgot yesterday with the technical issues. I forgot to thank the organizers, and especially Dr. Sauer and Dr. Felipe in here, and Dr. Uciel, who's not here, but all the organization was wonderful, and they invited me, and I was very rude not to thank you. So I would like to share just two brief ideas, because Barry took my part of my time. I'm sorry. Just two brief ideas. In support of what Barry was saying, and something that Professor McHill said yesterday about the religious illiteracy. And I think there is a very strong point. And if we think about how to respond to this, what I called low-intensity discrimination, that there is something that probably is not intended to be discrimination, something that is not persecution, open persecution, but that is affecting the free exercise of religion. Then how can we respond to that? Well, I think one important thing is fighting the religious illiteracy. And as I understand that term, many times our government officials and even the society at large, they don't know about the religion and they don't understand why a person is claiming for example, for accommodation because of their religion. So in my experience, and I think I am by far the less experienced of this panel, but in my experience, many times the fact of shedding light on the reason of the claiming helps a lot to open the door to an accommodation. And for example, in the accommodations in the workplace, probably the employer won't deny an accommodation on religious grounds because he's a persecutor or because he's trying to trump the religion development of the people and so on. It's just they don't understand, or they can think that, for example, the slippery slope argument of if I admit this accommodation, then I will be opening the door for any kind of accommodation. And if you look at the statistics, the numbers, that is not true. That is simply not true. There is no a huge amount of people claiming for this kind of accommodations. Usually it's just a very few. So, and on the other hand, why is he asking not to touch this, or not to eat this, or not to work on this day, or whatever? Maybe my employee is just lazy. Maybe he has a party, or he has a game, and so on. So just shedding some light on the religious. There's our four panelists. Okay, he's welcome. Shedding some light on the religious beliefs, I think it could help in many times. So making a good case. And the second, and briefly, the second idea is that I think we need to understand that the cultural war is not the fight of the religious liberty advocates, because many of religious liberty, religious freedom advocates, we are religious people, and we have our beliefs, and we think our beliefs are the best for the society. But religious liberty is not about advancing the religion, but it's about to setting the scenario so the religion can grow by themselves, by itself. So that's why I was asking Professor Durham today about neutrality, and he was right that the neutrality is a very complex concept. But let's talk about fairness for all. We, as religious freedom advocates, should understand that the goal of our work is not to impose our religious convictions, but to make the world a place where there actually can be fairness for all. And that way, on one hand, we can be protected, no matter who is in charge, who has the power, because that changes very quickly. And on the other hand, I think that is actually the best for society. And I think there is a proper response to this kind of issues we are talking about. Sorry.
Thank you very much. Do the panelists want to give one more contribution to each other? Any other point? If not, do you have any questions or very short contribution? It's okay, so I think everybody wants the lunch time, which is fine. And I thank you very much for your contributions to all the panelists. And now we have our lunchtime. We'll be back at 2, and we have a special.
Uma sugestão, nós tirássemos uma foto com todos os presentes, aí na frente, é possível isso num instante, ao final.
É possível ou não?
Se for bem rápido, nós temos basicamente 1 hora para almoçar e voltar.
So we had a suggestion that we took a picture here with the participants that are here, and then we go to our lunchtime and we come back here at 2 p.m. for our paper sessions. Thank you very much.